Comrade Ozzy. Ozzy, I've not seen you testing your machine.
Comrade Richard, I have already tested. It means you joined late.
I just need to make sure that the voice is okay. No, I'm fine. I'm fine, Minister. Thank you.
The voice is okay, and for sure today you can see the handsome guy.
I can see the dark guy, yes.
Recording in progress.
Welcome all members who have logged in this virtual mini plenary session. There will now be an opportunity for silence prayer or meditation. Thank you, honorable members. Before we proceed, I would like to remind you that the virtual mini plenary is deemed to be in the precinct of Parliament and constitutes a meeting of National Assembly for debating purposes only. In addition to the rules of virtual sittings, the rules of the National Assembly, including the rules of debate, apply. Members enjoy the same powers and privileges that apply in a sitting of the National Assembly. Members should equally note that anything said in the virtual platform is deemed to have been said to the House and may be ruled upon. All members who have logged in shall be considered to be present and are requested to mute their microphones and only unmute when recognized to speak. This is because the mics are very sensitive and will pick up noise which might disturb the attention of other members. When recognized to speak, please unmute your microphone and connect your video. Members may make use of the icon on the bar at the bottom of their screens, which has an option that allows a member to put up his or her hand to raise points of order. The Secretariat will assist in alerting the chairperson to members requesting to speak. When using the visual system, members are urged to refrain or desist from unnecessary points of order or interjections. Honorable members, we shall now proceed to the order, which is debate on Vote 25, Justice and Constitutional Development Appropriation Bill. Now I recognize the Honorable Minister for Justice and Constitutional Development. Over to you, Honorable the Minister Lamola.
Thank you very much, Honorable House Chairperson, members of the executive present, Deputy Minister for Justice and Constitutional Development, Mr. John Jeffrey, and Deputy Minister for Correctional Services, Nkosi Patekile Olumisa, Chairperson of the Portfolio Committee on Justice and Correctional Services, Honorable Magwanisha, Honorable members of the Portfolio Committee on Justice and Correctional Services, Honorable members of the House, the Director General for the Department of Justice and Constitutional Development, Advocate Mashawane, the representative of the National Prosecuting Authority, Advocate Anton Duplessis, distinguished guests, ladies and gentlemen, it is perhaps a great coincidence of fate that we gather on this historic day, Africa Day, to discuss how South Africa as a sovereign state can continue to deepen constitutionalism, respect for the rule of law, promote the respect of human rights, and provide quality and state legal services, as well as access to justice, which continuously restore the dignity of the people. This budget vote for the Department of Justice and Constitutional Development is presented on the backdrop of the 25th anniversary of the Constitution. In an article which transverses the history of our great Constitution, former President Thabo Mbeki makes a point that none will refute, and that is, this historic document seeks to establish a social order and governance system that is the direct opposite of what the Act of South Africa in 1909 and D.F. Malan and his National Party sought to impose in our country, building on and consolidating 3 centuries of colonial conquest, oppression, and exploitation, unquote. House Chairperson, as we celebrate this historic document, We convey our gratitude to the Speaker for acceding to our request for a debate on the Constitution during a joint sitting of Parliament on Friday, the 28th of May, 2021. Honorable members, on this day in 1963, 58 years ago, Pan-African revolutionaries like Kwame Nkrumah and many others gathered in Addis Ababa on the invitation of the Ethiopian Emperor, Haile Selassie. As a collective, they formed the Organization of African Unity, which we now know as the African Union today. House Chairperson, the words of Emperor Haile Selassie at this gathering are a clear demonstration of what the liberation of South Africa meant to the other states on the continent. Emperor Selassie said the following: "Our liberty is meaningless unless all Africans are free. Our brothers in South Africa cry out in anguish for our support and for assistance. We must align and identify ourselves with all aspects of their struggle. It will be betrayal were we to pay only lip service to the cause of their liberation and fail to make our words to match our words with action." Unquote. Honorable members, it is this firm commitment towards our liberation that helped us break the stranglehold of apartheid. Our African brothers and sisters spared no efforts to help us break a regime premised on systematic corruption and total disregard for human rights. We want to take this opportunity and wish all Africans a progressive Africa Day. We celebrate and acknowledge our successes in the fight against colonialism and apartheid. We also reflect on the journey ahead in terms of common challenges that Africa is confronted with. Today, we table a budget which advances a new social order and enables us to uproot the legacy of apartheid and the remnants of society which had no regard for human rights. The budget allocation for the Department of Justice and Constitutional Development for the financial year 2021-2022 amount to 21.5 billion. This is inclusive of the allocation for the National Prosecuting Authority and transferred to the two constitutional bodies, namely the Public Protector and the South African Human Rights Commission. In addition, the budget allocation also provides funding for the Information Regulator as well as transfer to the Legal Aid South Africa, the Special Investigating Unit, and the direct charge to the National Revenue Fund in respect of magistrates' salaries. This budget enables the department and its entities to execute their respective constitutional and statutory mandates. The above-mentioned budget was reduced by 2.4 billion rand. The 2 billion rand is allocated to Legal Aid South Africa, 437.9 million rand to the Special Investigation Unit, 329 million rand to the Public Protector South Africa, and 195 million rand to the South African Human Rights Commission. Further, the table budget also includes an amount of 2.4 billion rand for the direct charge to the National Revenue Fund in respect of magistrate salaries. To combat crime, fraud, and corruption, the National Prosecuting Authority's allocation for 2021-2022 amounts to 446 billion rands. On an amount of 106.4 million rands has been set for the investigative directorate, whilst an amount of 40 million rands is provided for the establishment of 4 additional special commercial crimes courts in Limpopo, Mpumalanga, Northern Cape, and the Northwest. The specialized commercial crimes courts are central to the fight against corruption and will contribute to the successful implementation of the anti-corruption strategy. The SSS have been established in all provinces. All serious economic crimes, including corruption and fraud cases, are being channeled through these courts. Cases enrolled in these courts are being monitored separately to enable targeted interventions where necessary. We will also continue to roll out sexual offences courts. They play a critical role in the fight against gender-based violence and femicide. In the current financial year, a total of 100 sexual offences courts will be dedicated in terms of Section 55A of the Sexual Offences Act to improve the adjudication of sexual offences matters. The modernization of the criminal justice system continues to be one of the JCPS cluster's priorities. Hence, an amount of 622.2 million rands has been allocated for the integrated justice system. A further 524.3 million rands is set aside for the department-specific modernization project. Honorable members, the review of the criminal and civil justice systems remains a priority area of focus. We have assigned this important task to the South African Law Reform Commission, and we have commenced with initiatives to increase the capacity of the Commission to carry out this task. During the 2020-2021 financial year, the department was able to complete the consultation process regarding the rationalization of the magisterial districts in respect of the Eastern Cape and KwaZulu-Natal provinces. In the current financial year, we will commence with the second and last phase of the rationalization project. This phase entails the rationalizing of the areas under the jurisdictions of the divisions of the High Court and the judicial establishments of both divisions of the High Court and the Magistrate Court. The terms of reference of this important phase of the rationalization project will be published in the Government Gazette in due course. A rationalization committee will be established to provide a detailed report and recommendations which will enable us to finally dismantle the remaining apartheid-era judicial demarcations and fully align the courts to the new democratic dispensation. Their work will culminate in the equitable distribution of judicial posts in both the High Courts and the Magistrate Courts. This will translate into greater access to justice for all, as each court will have the requisite capacity and capability to dispense justice to the local community. The department is continuing with the improvement of infrastructure to increase access to justice. Despite the slowdown in the capital infrastructure projects, which are coordinated through the Department of Public Works and Infrastructure, the department was able to meet its targets in the last financial year. For instance, the Durban Point Magistrate Court, which I had the pleasure of opening on 26 March 2021, is a case in point. This court, with its immaculate design and modern fittings, will go a long way in alleviating the congestion at the main district court of Durban. This court will be the first court in South Africa where a domestic violence survivor can apply online for a protection order. We hope to learn important lessons from this pilot as we prepare to roll out a more comprehensive version throughout the country. The construction of the Dimbaza Magistrate Court in the Eastern Cape was also completed in October 2020. The department also completed major refurbishment and upgrading in a number of courts. The department, in intensifying its efforts to utilize ICT as a strategic enabler and a mechanism to improve access to justice, has done some considerable work. Through technology, the serving of court process like summons, which traditionally are served physically by the police and sheriffs, will now be able to be served electronically to the parties, thus freeing up time to focus on service delivery priorities. The integration of this technology across the justice system will also enable a real-time single view of individuals engaging with the justice system, where, for example, an integrated system will indicate at any given time whether individuals have protection orders against their names or are applying for maintenance from different defendants at different courts across the country. In the current digital era, it has become imperative to have an effective online presence between citizens and the department. These initiatives improve citizen services through greater flexibility, cost savings, faster delivery of justice services, less paper to waste, and certainly increased professionalism. We will ensure that the justice services are accessible to citizens via digital platforms. The services will include the following: maintenance services available on the DOJ Internet Portal online. Protection orders available on the DOJ Internet Portal online. Expungement of criminal record services accessible via digital platform. In March 2021, we announced plans to transfer the land rights management facility housed within the Department of Agriculture, Land Reform and Rural Development to Legal Aid South Africa. The implementation of these plans commenced in April 2021. This is an extension of the entity's mandate to ensure access to justice and the right of a person to have legal representation as envisaged in the Constitution. It's materialized in pursuit of land justice, which has long evaded the majority of the population, in particular farm dwellers and farm workers. Honorable members, I would like to really commend this House and our portfolio concerned. The work you have done as members of this committee on the 3 GBV bills is an invaluable contribution. These bills are the fruits of the Presidential Summit on Gender-Based Violence and Femicide in 2018. The high conviction rate of 75.8% for sexual offenses reflects the firm commitment to deliver justice to the vulnerable and members of society. The fight against corruption is a key priority for the NPA, as this scourge impaired service delivery undermines the rule of law and costs citizens trillions in monetary value. A review of existing anti-corruption legislation and institutional arrangements in line with implementing the National Anti-Corruption Strategy continues to be a priority. The National Anti-Corruption Strategy, adopted by Cabinet in November to deliver on its work. The Anti-Corruption Task Team Case Management Committee was revived and serious corruption cases in cooperation with all other stakeholders. A total of 128 cases were registered with 91 cases under investigation. 19 were closed and 18 cases are currently before court. 25 new cases were included on the list of the ACTT priority corruption cases. One of the most important projects within the NPA in terms of corruption is increased coordination amongst relevant entities in fighting corruption. An example of this is the Fusion Center, in which corruption related to COVID-19 funds are dealt with. The number of incidents registered was 146, with 118 incidents under investigation and 28 closed. The Asset Forfeiture Unit plays a critical part in the fight against corruption. It has delivered significant returns in the past year, illustrating that crime does not pay. In an effort to curtail the increase of corruption, the MPA obtained freezing orders to the value of 601 million in corruption or related offenses in the last financial year. The NPA, and in particular the AFU, is implementing significant prioritization initiatives during the 2021-2022 period in partnership with the DPCI, the SSSU, the SIU, FIC, SARS, and the Reserve Bank. Two main projects are the establishment of the Fusion regional offices and the expansion on the anti-corruption task team presence in the regions. The purpose of both these projects is to fast-track the processes of referral of high-value cases with asset forfeiture potential to the AFU. The NPA finalized a high-performance strategy in the AFU space to address the fight against priority crime. A process is underway to amend the POCA legislation in order to increase the effectiveness of the asset recovery regime. In partnership, the AFU and the Investigative Directorate, through closely working together, are fast-tracking cases with a view of initiating asset forfeiture proceedings and the recovery of stolen money from all jurisdictions, both nationally and foreign. These include cases which are under the state capture related processes. Honorable members, the Investigative Directorate, with its multidisciplinary approach, brings prosecutors, investigators, and analysts together in order to combat serious, complex, or high-profile corruption. This is the cornerstone of addressing corruption. The NPA currently has its full top leadership team in place and is prioritizing the filling of other key senior posts in the coming months. This will bring much needed stability and leadership innovation in the National Prosecuting Authority. The talk of the coming few months, expediting high-profile corruption cases nationally and provincially, a stronger focus on serious and violent and organized crime, and crimes that disproportionately undermine public safety. Capacitating the NPA through recruiting crucial additional skills and expertise and capabilities to respond to existing and emerging priorities. Enhancing staff morale and well-being. It should be noted that high conviction rates were maintained in all court forums, The conviction rates of 93.8% in the High Court, 82.6% in the regional courts, and 95.9% in the district courts were recorded. Regardless of these impressive conviction rates, the COVID-19 pandemic had a negative knock-on effect on the number of outstanding court rolls and backlogs. A national integrated criminal case backlog management plan was developed by the department to create a framework and to provide guidelines for the management of historic and current criminal cases backlogs in the lower courts, which resulted from the lockdown measures. The NPA, the department, and the Legal Aid South Africa and the judiciary participated in the optimization project, which is led by the Deputy Minister, Mr. John Jeffrey. Cases at a local level are prioritized, backlogs are monitored, and steps to address the local challenges are agreed on by local stakeholders. Several measures and interventions were over the years initiated to remove apartheid era laws from the statute books. The purpose of the Justice Laws Rationalization Act 1996 was to remove colonial and apartheid era legislation. A rigorous and robust constitutional review by the Constitutional Court also resulted in the declaration of a myriad of statutory provisions found by the court to be inimical to the values and ethos contained in the Constitution. Numerous other projects were also initiated or supported by government, such as the statutory law revision project conducted by the South African Law Reform Commission, which focused on the legislative compliance with the Section 9 of the Constitution and the removal of archaic terminology and reference to repealed legislation. However, some pieces of legislation which are not overtly unconstitutional, unjust, or anti-democratic, nonetheless still form part of our suite of legislative enactments designed to foster the policies of apartheid have survived. A few examples of these statutes include the Transkei Penal Code, Act 9 of 1993, the KwaZulu-Natal Act on Code of Zulu Law, Act 16 of 1985, and the Righteous Assembly Act 17 of 1956. Following the approval of the inclusion of the project onto the program of the South African Law Reform Commission, I appointed experts to assist the South African Law Reform Commission in undertaking this critical task in November 2020. A call for submission was widely publicized in May 2021, seeking public input into the repeal of these statutes. The continued existence of these laws in our statute books is not compatible with our constitutional order. We will lead the process to review and repeal these statutes. At the same time, great care should be taken to ensure that the abrogation of these statutes does not leave or create a lacuna in the law. By way of an example, the current Extradition Act as well as the Insolvency Act come to the fore. The Extradition Act of 1962 is an outdated act which is not in line with the modern laws and practices. We will introduce a new bill which seeks to clarify the roles and responsibilities of the different functionaries and put procedures in place to expedite extradition requests. This bill is aimed at ensuring that South Africa is not a safe haven for international fugitives. It is anticipated that the South African Law Reform Commission will finalize Project 142, investigation into legal fees, including access to justice and other interventions, by the end of the first quarter of 2021-2022 financial year. Chapter 13 of the NDP refers to building a capable and developmental state, with the first objective being a state that is capable of playing a developmental role, as well as functioning litigation services, is fully aligned with this vision. The Solicitor General is also developing a comprehensive policy framework to address the transformation of the legal profession in a systematic manner, focusing on work distribution, management, oversight, skills development, and exposure, as well as reporting. This policy framework is done with a particular bias to previously disadvantaged individuals. I'm also pleased with the progress to date on the Legal Sector Code. Together with the Legal Practice Councils, we have concluded all internal processes in developing the Legal Sector Code. The transformation of the legal profession is not only a matter of demographic change, but it must also be linked to the quality of work that historically disadvantaged practitioners get in.
Thank you, Honorable Minister. Honorable Minister, your time has expired. As I show my face is an indication that your time is about to expire. Thank you very much, Honorable Minister.
Thank you.
Honorable members, now we shall proceed to Honorable Makwanisha, the ANC.
Thank you very much, Honorable Chairperson, Honorable Minister Lamola, Honorable Deputy Minister John Jeffrey, Honorable Deputy Minister Patekile Olumisa, Ministers and Deputy Ministers present here, Honorable Members. We are mindful that the situation we are in is unprecedented. So we need a careful balance between the management of debt service costs and service delivery. Because if both are not properly managed, they can be a threat to our democracy as a failure to manage either of them can lead to a failed state. Therefore, the budget cuts should be fit for purpose. Our democracy requires stable, well-functioning justice system to prosper. Delivering justice services is labor-intensive, so budget cuts affect our legal system severely. We are therefore concerned by the extent of the cuts to the salaries budgets. We remain concerned by the growing number of case backlogs. Preventing these backlogs from overwhelming our system will require added resources. Budget reductions at the Legal Aid South Africa has meant a cut in posts which will increase the number of pending matters and case backlogs in criminal courts. This also means that fewer clients can be assisted in civil matters and with advices. We do not support budget cuts to the NPA and the SIU. These are entities that can bring money back to the state. We believe that this can also undermine efforts to rebuild our economy and our society. We cannot afford to have a situation where criminals in organized crime have more capacity than the state. I must hasten to say that this is a global phenomenon, but governments all over the world have a responsibility to turn the tide against criminal syndicates. We do not support the budget cuts in the Public Protector and the South African Human Rights Commission. The Chapter 9 institutions uniquely contribute towards strengthening our constitutional democracy, and we have a constitutional duty to assist them. We have raised our concerns about the department's poor performance, attributing this partly to a lack of leadership at senior management level as a result of high vacancy rate. We therefore welcome the steps taken to stabilize the department's leadership. A new Director General, Advocate Mashabane, has been appointed, as well as the Deputy Director General Corporate Services, Ms. Mamecha, and the Chief Master Advocate Mafojane. We congratulate them on their appointments. We also welcome the department's intention to finalize its microstructure and the intention to reduce the SMS vacancy rate to 10% and below. The intention to accelerate ICT projects aimed at fast-tracking court modernization and digitization is welcome. We also welcome the intention to designate more sexual offences court this year. Last year, the department implemented a Justice Rapid Results Challenge at selected courts aimed at rapidly eradicating backlog in domestic violence cases. We will continue to monitor the backlogs in respect of GBV cases. We note that the department has targeted 75 courts this year to be made compliant with a strategy for universal access for persons with disability. We are also pleased about the appointment of regional heads to the offices of the State Attorney. We also note the ongoing engagement with the National Treasury on the framework contract model to support the fair and transparent procurement of litigation services. We also welcome the intention to develop a policy for the management of state litigation. We also note that 5 specialized commercial crimes courts have been established so far. We note the Protection of Personal Information Act will commence fully on the 1st of July this year. Therefore, we are pleased that the information regulator has received added funds over the MTEF for the needed capacity. We will continue to monitor the progress of corruption matters referred to the NPA for prosecution, particularly those involving alleged corruption in COVID-19 related procurements. We will continue to monitor the NPA's recruitment drive. We welcome the transfer of the legal representation function currently undertaken by the Department of Agriculture, Land Reform and Rural Development to Legal Aid South Africa to assist the indigent that seek land justice. We agree that the SIU's funding model must be addressed. We propose to request the Speaker of the National Assembly that she brings the matter of the monies owed by the state institution to the SIU to the attention of the President. We note that the Public Protector of South Africa's intention to develop amendments to the Public Protector Act. We welcome the recent collaboration between the Public Protector of South Africa and the South African Human Rights Commission. We welcome the decision of the Public Protector to open a new regional office in Thohoyandou, and also the decision to install complaint drop boxes at certain magistrate courts countrywide to enhance access to services. We will monitor the progress of the transfer of the South African Human Rights Commission's PIA function to the Information Regulator, which will take place soon. We will monitor the South African Human Rights Commission's work in respect of the National Preventative Mechanism established in terms of OPACT Act as the designated independent monitoring mechanism under the Convention on the Rights of People with Disabilities. We are aware that some departments do not cooperate with the South African Human Rights Commission, and we have asked for a list of errant departments so that the matter can be taken up to the Speaker's office with the leader of government business. We recommend that this budget be supported. I thank you, Chair.
Thank you, Honorable Member. Now we'll move on, Honorable Members, to, I recognize Honorable Breda Bank from the DA.
Thank you, Honourable House Chair. Honourable Members, the Department of Justice and Constitutional Development has submitted an annual performance plan that gives the impression of it being on the very brink of turning the corner, of being on the very brink of improvement, almost as if there really is someone there who is actually in control, actually has a vision of how to turn it around, someone who is actually capable of implementing this. So the annual performance plan looks deceptively convincing and invites a false sense of security. It is cleverly crafted to make us all feel as if everything is going to be okay. It is filled with details of wonderful sounding 21st century plans that on paper look as if the only way is up. And we all, myself included, so desperately want this to be true. But on a closer, more sober, realistic inspection, it becomes clear, painfully so, that it is all words on paper, and worse, it is words on paper that we have heard before. Certainly, it is served up in a different guise, updated for the year 2021, but it really says nothing new, and very little new has happened. There has been little to no progress in the department, and its performance continues to languish in many very important areas has declined. The department has failed to deal with important disciplinary issues that have had a seriously negative impact on its performance and functions for over a year, and these matters are still not near completion. Bearing in mind the negative effect on the ability of the department to properly perform, this lackadaisical approach is unacceptable. But honourable members, this speech is rather about suggestions for improving performance in key areas, and specifically in the National Prosecuting Authority. As Adrian Besson wrote yesterday, the National Prosecuting Authority should be an attractive employer for smart lawyers who have no ambition of driving a Ferrari, but it isn't. It used to be, it must be again. The NPA was able to attract outstanding lawyers such as Billy Downer SC, Sax Mapoma, Lungi Mahlati, Rita Mankis SC, Herman Broodryk SC. It has been less successful in keeping them. Headhunting has always been a scourge in the NPA. It is difficult to counter. But there are outstanding lawyers whose passion it is to be the people's lawyers, who do not do it for the money, and those must be found and kept. There is a great number of very experienced prosecutors, expert litigators with decades of experience, who are reaching retirement age. This experience must not be lost. If the NPA is to prosper, a way must be found to harness this experience for the good of the prosecuting authority, to mentor young prosecutors, to teach them the practical skills of litigation that cannot be taught in any university. What South Africans need and want to see now are more and faster prosecutions. They are tired of waiting and are entitled to start seeing results. There must be tangible consequences for the astonishingly bad behavior and grand-scale larceny we have witnessed over the past decades. Those guilty of state capture and massive fraud, theft, and money laundering must be charged now. Not on each and every possible charge imaginable, but on 2 or 3 solid counts, convicted and taken out of the system. Only when it is clear that the game is not worth the candle will we see a change in behavior. If the NPA lacks the capacity, and it does, they must find the budget and resources to use private lawyers to prosecute while rebuilding NPA capacity. This is not new. It has been done before with great success. The litigation capacity of the NPA must be a priority. Young lawyers who want to pursue a career in litigation can find no better learning school. Develop a program where young graduates can join the NPA for a finite period, similar to articles of clerkship or pupillage. The time will not be wasted, and many of them may decide to stay. Consult with the Legal Practice Council to employ young lawyers. There are hundreds who are unable to find jobs. Many practitioners have expressed the desire to assist to get the NPA back on its feet and would make themselves available to assist with prosecution for finite periods. These are avenues that must be utilized in order to attend to the massive existing backlog of cases, a backlog that increases annually. As set out in a study by the Dalla Oma Institute, the Constitution provides that the NDPP sets prosecution policy and directives. The NPA Act says this must be set in consensus with the Minister of Justice. The prosecution policy directives of June 2014, which the NPA treats as confidential, contain a number of provisions that have the effect of discouraging prosecution. This needs to be addressed on an urgent basis in order to encourage both accountability and transparency in the process. In order for the criminal justice system to function optimally, we must, at all costs, continue to fight for and defend an independent judiciary. Spurious and unfounded claims against the judiciary must be confronted and dealt with, and those making them must be held to account. It is too easy to cast unjustified aspersions on the judiciary with no consequences. This cannot be allowed to continue. All it does is undermine the constitutional authority of the judiciary and ultimately bad for our constitutional democracy. The Democratic Alliance will in the very near future be promoting legislation calling for an amendment to the Constitution and for the creation of a new Chapter 9 institution in the form of an Integrity Commission. We hope that we will have the support of other parties in this House. We hope that we can ultimately submit it as a committee bill, in so doing demonstrating that we are all in this House, regardless of political affiliation, serious about addressing corruption and theft, and that we are serious about holding those responsible to account. We hope that it will ease the massive burden on the NPA and bring about quicker, more effective prosecutions and convictions of those responsible for grand-scale corruption and theft. By so doing, it will set us on the path of ensuring that those who steal from the fiscus, from the taxpayers, and from the poor will end up in prison where they belong, and in a short space of time, and have the effect of putting a stop to this endless looting with no consequences, while freeing the NPA to concentrate on its core function of prosecuting crime in general. If the Department of Justice is indeed going to make an improvement, if the Minister is serious about turning it around, I would encourage him to seek to include all the assistance he can muster, to harness the goodwill that exists to help the department to succeed. It is in the interests of all South Africans. I thank you.
Thank you, Honorable Member. Now I recognize Honorable Yako from EFF. Honorable Yako, over to you.
Chairperson. Chairperson, the EFF rejects this budget vote. Minister Lemula, who was part of a generation of youth leaders in this country, who redefined the nature of our struggle post-1994, has now become so comfortable in getting the perks that come with being in power that he forgot what they defined as their generational mission. If he has not forgotten, how then do we explain that the department he leads, to which the National Prosecuting Authority reports, has blatantly refused the past 27 years to prosecute apartheid criminals? Why has that murderous apartheid criminal F.W. de Klerk not been charged for the murder of so many Black people in this country, including the murder of the Mpendulo children in 1993? He publicly admitted to have authorized that murder. Why has this democratic state dragged its feet in prosecuting white criminals? Why has the NPA dragged its feet in charging and prosecuting Marcus Joost, perhaps the biggest kingpin of those who are corrupt post-1994? The list of white criminals still walking about freely is too long. This lays credence to the perception of many that justice in South Africa has eyes and ears, and that it particularly does not like Black faces and views whites as saints. This is not the way to go about administering justice in a democratic society. The NPA still operates under the colonial and apartheid modus operandi that all Blacks are savages and all whites are saints. Miller Tohi, a renowned Indian racist, as head of the NPA, only strengthened the stranglehold of this racist to have over our criminal justice system. Over and above that, she has failed to initiate any significant corruption case against any of the army of corrupt officials and business people we have in this country. Her only priority, her brief, is to harass those who are against her backers. Contrast the treatment of Patohi to that of the public protector, Busisiwe Mkhwebane. The public protector is today threatened with ejection from the office by the DA, supported by the ANC, a party supposedly fighting for the emancipation of Black people. The public protector's only sin was to go after those who are considered untouchable in our society. She went after ABSA and how they corruptly benefited under apartheid. She went after the darling of our influential right-wing groups, Pravin Gordhan, a self-proclaimed crusader against corruption, but who is himself the greatest enabler of white corruption in this country. South Africans are fooling themselves if they think the courts are impartial adjudicators of disputes in this country. When the then public protector rightfully invested the corrupt conduct of the then President Jacob Zuma, the courts affirmed her powers to do so, and even said that the rulings of the public protector cannot be ignored unless set aside by the court of law. Today, the same office of the public protector makes similar rulings against the darlings of the establishment. Busisiwe Mkhwebane is slapped with personal cost orders, and Parliament, under the leadership of the ANC, threatens to impeach her. The modus operandi is the same everywhere, whether in the prosecution of Fees Must Fall activists or the arrest and prosecution of community leaders agitating for change and service delivery. The department has also not lifted a finger to investigate the allegations that some judges in our courts are bought and that they structure their judgments in such a way that they arrive at a predetermined conclusion. The capture of our judiciary would mark the death of democracy as we've come to know it. It must be fought and prevented by all means possible. Mr. Lamola has betrayed the ideals he has committed himself to as part of that generation of youth leaders. He is now presiding over a department that is hell-bent on preventing Africans from seeing justice in their lifetime. And therefore, again, Chairperson, the EFF rejects this budget vote.
Before I thank you, Honorable Member, Honorable Khatebe, I saw your hand up on the platform.
No, Chairperson, I was raising on a point of order that the member was attacking the person who can be removed by Parliament. That is the Director of the National Land of Public Prosecution. I think that it was unparliamentary. Thank you, Chair.
No, sit down, Khadebe, man, sit down. Hey.
No, wait, Honorable Members. Honorable Members, you are aware that you cannot make a direct personal attack to an individual who cannot defend herself in Parliament. We must all desist from doing that. We shall move, Honorable Members, to Honorable Simango, IFP.
Thank you, Honorable Chair, Honorable Minister Lamola, Honorable Deputy Ministers, and Honorable Members of the House. This year marks the 25th anniversary of our Constitution, while a number of programs are in the pipeline to commemorate this milestone. The IFP wishes to highlight critical areas that would benefit from any funds the department would divert to such celebrations. The Department of Justice is an essential service whose functions have long been crippled by a lack of resources. The state of affairs was exacerbated by the pandemic. It is with this knowledge in mind that the IFP remains concerned about the budget reduction for the programs of the department. The first area to be hit by budget cuts is the filling of critical vacancies across the department, negatively affecting the department's services delivery and compromising the rights of court users to access to justice. The IFP welcomes the filling of critical vacancies at the top of the organizational chart. However, the filling of crucial roles that are client-facing must be expedited to allow efficient service delivery. The high vacancy rate in the department has been compounded by the slow pace of the recruitment processes. The IFP trusts that the department's plan to finalize its reconfiguration of its structure will be implemented with urgency it deserves. The IFP has expressed and wishes to express again its disappointment in the consistent budget cuts experienced by Legal Aid South Africa. Since 2015 to 2016 period, Legal Aid has lost 449 million rand and continues to lose funding. The bulk of this budget is allocated to employee costs, and as such, the budget cuts directly affect the legal aid's ability to assist those people who cannot afford private legal assistance. The IFP does not support any reduction of legal aid's budget, which will lead to an increase in backlogged cases, affecting the right to access to courts and speedy legal process for far too many people. Further, budget cuts will directly impact the number of remand prisoners in our correctional facilities, as the already limited staff complement will continue to be stretched thin. The IFP notes that despite the persistent cuts, Legal Aid has managed to achieve impressive results, yet bears the brunt of the department's fiscal challenges. The IFP has long been calling for the establishment of an independent, well-resourced anti-corruption integrity commission under the auspices of Chapter 9 to investigate and prosecute high-level corruption in the public service. This institution will strengthen our constitutional democracy and is even more vital now with the release of large amounts of money for essential procurements. As we look back the work of the Constitution and look forward at its potential impact, the IFP trusts that the Department of Justice is recognized through appropriate funding as a critical agent of transformation and buttress of the rule of law. The IFP supports the budget, and I thank you, Honorable Chair.
Thank you, Honorable Member. Now I recognize Honorable Muda from FF+.
Thank you, Honorable Chair. The mandate of the Department for Justice and Constitutional Development of promoting the constitutional democracy in South Africa should be measured in the department's ability to uphold and protect the Constitution, and the rule of law, to render accessible, fair, speedy, and cost-effective administration of justice in the interest of a safer and more secure South Africa. Chair, the Freedom Front Plus share the opinion of Professor Koos Molan of the University of Pretoria, who published a book in 2019 with the title, "There is no Supreme Constitution." The set of myths perceived in the Constitution is quite clear. The Constitution is not supreme, nor is it definite, constant, or enduring. If individuals rely on it for protection, they live in a fool's paradise. The Constitution is vulnerable to potent socio-political forces. It changes continuously and often profoundly regardless of stringent amendment requirements. The threefold separation of powers is more metaphorical than real, and therefore unable to secure effective checks and balances. Through institutionally separated with their own personnel and functions, the three powers are ordinarily integrated in a single dominant political leadership committed to achieving the same ideological goals. The Bill of Individual Rights cannot guarantee justice, because rights are subject to the ideology-driven exercise of the judicial interpretation, often with damaging consequences for those relying on the Bill of Rights. South Africa needs an improved mode of constitutionalism, equipped with a sounder system of checks and balances, and better endowed towards the achievements of justice through a balanced constitution. Honourable House Chair, according to the Constitution, the public sector, which include the public service, must be impartial and professional. Consequently, the forming of relationships, patronage, appointments, promotions, delivery of services, and the awarding of contracts on account of involvement in or in exchange for loyalty to the ruling party or any of its factions is impermissible and unconstitutional. Since the Constitution took effect, potent forces have exerted themselves with marginalized these values and principles. The South African judiciary should uphold these values. The committee report before the House today tells a story of a department with unfilled critical positions at senior management level. An underfunded special investigation unit with unfilled critical positions, reduced budget for the National Prosecuting Authority, vacancies at the Information Regulator, serious service delivery concerns at the Master's Office. Yet another turnaround strategy in the State Department at the State Legal Services. A poor audit outcome with another turnaround strategy, case backlogs in lower courts, budget reductions, amidst a constrained fiscal environment, a partial and political driven Human Rights Commission, a political charged and failed Office of the Public Prosecutor, an aging and unstable ICT infrastructure that caused the disruption of services, poor contract management leading to irregular expenditure, inadequate management of people, compromised physical and information security, and an inadequate disclosure process of the contingent liabilities of state attorneys. Chair, over the medium term, the budget allocation for the department will be reduced by 7.8 billion rand. Chair, this department should have been put under administration long ago. The department is failing its mandate. Thank you.
Thank you, Honourable Member. Before I recognize the Deputy Minister, Honourable Mahlaule will take over after I've recognized the Deputy Minister of Justice and Correctional Services responsible for justice and constitutional development. Over to you, Deputy Minister.
Thanks, House Chair. Honourable Minister Ronald Lamola, members of the Executive, the Deputy Minister for Correctional Services, and Nkosi Patikile Holomisa, the Chairperson of the Portfolio Committee on Justice and Correctional Services, Honourable members, the DG, Advocate Mashabane, and other members of the department, and distinguished guests and friends. As we celebrate Africa Day, we are once again reminded of the words of Kwame Nkrumah when he said that, and I quote, "Freedom is not something that one people can bestow on another as a gift. They claim it as their own, and none can keep it from them." Freedom and access to justice go to the very heart of what our department does as we work towards building and deepening constitutionalism and respect for human rights and the rule of law. As we are celebrating Africa Month under the theme, the Year of Arts, Culture and Heritage in the year of Charlotte Maxeke. Charlotte Maxeke was a pioneer and an activist when, at the turn of the 20th century, she became the first African woman in our country to attend university when she enrolled at Wilberforce University in the United States of America. Upon her return to South Africa, she committed herself to improving the lives of African women and children. She was also actively involved in helping women and children in prisons. She was unwavering in her commitment to women's rights. As a country, we say that we value women's rights and gender equality, yet many of the women of our country face gender-based violence on a daily basis. Addressing the scourge of gender-based violence and femicide and violence against women and children is a fundamental part of what our department does. During the past financial year, the 3 GBV gender-based violence bills were introduced. We note the hard work that is being done and the progress being made by the Portfolio Committee on these bills, and hope that the President will be able to enact the Criminal Law Sexual Offences and Related Matters Amendment Act Amendment Bill, the Criminal and Related Matters Amendment Bill, and the Domestic Violence Amendment Bill during this financial year. These bills provide for more protection for complainants of gender-based violence, more victim-centered mechanisms to be made available to them, and a stricter approach towards the measures to be taken against perpetrators before, during, and after the trial. Our sexual offences courts and our Tutuzela care centres also play a critical role in the fight against gender-based violence and femicide. As the ministers indicated, a total of 100 sexual offences courts will be designated in terms of Section 55A of the Criminal Law Sexual Offences Act to improve the adjudication of sexual offences cases. The designation will mean that members of the public will know what they can expect from a sexual offences court, as a designated court will need to conform to the minimum requirements set out in the regulations. When it comes to domestic violence applications for protection orders, it's extremely concerning that in excess of 194,000 such applications were made in the last financial year. Of these, a staggering 21%, that's nearly a quarter, come from KwaZulu-Natal, followed by Gauteng at 14% and Limpopo at 13%. When it comes to the types of abuse, one complainant can register more than one type of abuse, and there were 137,800 instances of emotional, verbal, or psychological abuse, followed by 64,400 instances of physical abuse. Because these are domestic violence applications, we know that these atrocities are being committed by people who know each other, people who are or were in a relationship. These are not strangers attacking unknown victims. This is happening in our homes. Economic abuse is also a sad reality of the world we live in, particularly where parents and spouses default on their legal obligation to maintain their dependence. Plans are in place to introduce the maintenance online applications, or the MOLA system, as the initial phase of establishing a comprehensive electronic management of maintenance matters. Currently, magistrates' courts receive thousands of manual applications for maintenance claims, and at times the complainant is not aware of what documentation is required, which then leads to them having to make multiple trips to the maintenance court. The new system seeks to ease the current cumbersome process by creating a web portal for the submission of maintenance application forms online. It will also enable the user to track how far the application is in the system. The portal will further inform the user of their next court appearance. This innovation will take us a step closer to our goal of using technology to simplify lengthy processes and continue to improve access to justice services for all. This, as you'd heard from the Minister, is the first phase of the comprehensive electronic management of maintenance, and the solution will be piloted in our model court in the Point Branch Court in Durban this year before it is rolled out to the other 450 maintenance courts. Honourable members, in July last year, when we delivered our previous budget vote, we had to come to grips with COVID-19 and new ways of delivering justice in South Africa in such circumstances. Our main focus remains the optimal functioning of our courts and the justice system, as well as the protection of human rights and vulnerable groups in times of COVID-19. We're working closely with key stakeholders in our magistrates' courts, the chief magistrates, the NPA, Legal Aid South Africa, the Department of Correctional Services, the South African Police Service, and the Department of Social Development to ensure that we finalize the maximum number of cases that we're able to during this period. The magistrates' courts continue to grapple with huge case backlogs, which were already high even before the pronouncement of the state of national disaster in March 2020. These backlogs increased during the hard lockdown. From the records kept by the department, case backlogs stood at around 53% and 48% in the regional courts and district courts, respectively, immediately before the announcement of lockdown in March 2020. By March 2021, the backlogs had decreased to 48.87% and 14.14% in respect of the regional courts and the district courts, respectively. This is because of the continued focus which the department and our stakeholders have been putting on reducing the backlog cases and the prioritization of matters involving GBV and femicide, matters involving children, as well as corruption-related matters. Matters where there are persons awaiting trial are also prioritized. We continue with the implementation of measures to bring down the backlogs. As part of the measures underway, the department has procured over 1,500 new laptops with the requisite data and IT equipment for use by magistrates. This yielded results as many cases, particularly civil matters, were dispensed with on virtual platforms during the hard lockdown. There were 37,572 matters where audiovisual remand was utilized as a virtual appearance method with a detainee in DCS custody in the last financial year. Regular meetings of all stakeholders, except unfortunately the regional court presidents, as part of our court optimization committee, are held to discuss ways of unblocking operational challenges for the lower courts to function optimally. Our magistrates have to perform their duties at the very coalface of justice. The department is presently refining a draft magistrates bill, which is aimed at replacing the Magistrates Act of 1993 in order to engage with and obtain the inputs of the interested role players, including those of the Superior Court's judiciary. We're also developing legislation provisionally called the Lower Courts Bill that is aimed at replacing the Magistrates Court Act of 1944. It's common cause that all the legislative provisions pertaining to the superior courts and the judiciary of those courts were framed after our transition to democracy in 1994. The post-1994 constitutional order elevated the constitutional status of the magistracy. In terms of Section 68(1) of the Constitution of the Republic of South Africa of 1983, that would have been the constitution that the Honorable Mulder would have supported better than the one we have today. The judicial authority of the Republic was vested in the Supreme Court of South Africa. However, both the interim, the 1993 Constitution in Section 96, and the final Constitution in Section 165 vested the judicial authority in all courts. Magistrates' courts are also specifically mentioned in Section 166 of the Constitution as forming part of the Republic's judicial system. Magistrates are therefore just as much part of the judicial authority as judges of the superior courts. The Magistrates Act of 1993 emanates from an era before the advent of the new constitutional dispensation in South Africa. The Magistrates Court Act of 1944 has been amended on various occasions, but because it's still archaic, it is necessary to review the whole act. Progress has been made in this area of work, which is intended to transform the statutory framework regulating the structure and functioning of the lower courts and enhancing the independence, impartiality, dignity, accessibility, and effectiveness of the lower courts. The Minister of Justice appointed 24 senior magistrates to vacant offices with effect from the 1st of January this year, after having considered the recommendations of the Magistrates Commission. The Magistrates Commission has also finalized their recommendations for the filling of 165 vacant posts of district magistrates. A total of 476 candidates were shortlisted and interviewed by the Commission. It is anticipated the Minister will soon make appointments arising from the recommendations of the Magistrates Commission. And we would like to convey our appreciation to the members of the Magistrates Commission and the supporting officials in completing this mammoth task, that had to be staggered over a 4-month period due to the large number of shortlisted candidates and the commitments of the members of the Appointments Committee. The number of senior judicial heads that are currently suspended pending the finalization of their misconduct proceedings, as well as the period of time that it takes to bring these matters to finality, remain a matter of considerable concern. Honourable members, I'd like to pay tribute to the various officials and magistrates who continue to serve the public and ensure access to justice for all during this pandemic. Sadly, many of them passed away during the pandemic, and we wish to convey our sincerest condolences to the families of these officials and magistrates. And obviously at this point to also acknowledge with sadness the passing of Honourable Jackie Mofokeng, who was the whip to this committee. With regard to the sheriff's profession, I want to convey my appreciation to the outgoing chairperson and members of the South African Board for Sheriffs for further enhancing the work of the sheriff's profession and for the clean audits received during their term. With regards to the South African Human Rights Commission, in October last year, we had to bid a very sad farewell to the Commission's Deputy Chairperson and renowned human rights lawyer and activist, Priscilla Jana. She was responsible for the Commission's work on equality and dedicated her life to the struggle for liberation and democracy. And we're pleased that the committee is finalizing the process for the appointment of a replacement. As you'd heard, this is an important year for the information regulator. In June last year, the President issued a proclamation to bring into effect a number of the remaining sections of the Protection of Personal Information Act on the 1st of July last year. The last two sections, sections 110 and 114.4, will commence on the 30th of June this year. And those are the sections effectively dealing with the Promotion of Access to Information Act and transferring it to the information regulator. And in short, private and public bodies will have to ensure compliance with the Act by the 1st of July this year. Honourable Chairperson, as we celebrate the 25th anniversary of our Constitution, and in spite of what Honourable Mulder said, a Constitution which has been lauded around the world as being one of the most progressive, it is an opportune time to reflect on how far we have come as a nation. To once again quote Dr. Kwame Nkrumah, he said, and I quote, "Those who would judge us merely by the heights we have achieved would do well to remember the depths from which we started." As much as leaders from a certain opposition party would argue to the contrary, nothing good came from colonialism. We had, as the late President Mandela said, to suffer the indignity of being the skunk of the world. Those were the depths from which we started. But over the past 24 years, our 1996 Constitution has enjoined us to the attainment of human rights for all and respect for the rule of law. But there's still much to be done. Poverty, inequality, and discrimination stand in the way of the full attainment of the society we're trying to create, a society where every single person can claim freedom and human dignity as their own, and none can keep them from it. Thank you.
Thank you very much, Honorable Deputy Minister. Honorable members, we will now move to the next speaker, which is Honorable SN Swart, ACDP.
Thank you, House Chair. The overall allocation to the department is 21.5 billion, and the ACDP shares concerns with the budget cuts and the one-size-fits-all approach. These budget cuts will undoubtedly have a negative effect on service delivery in the courts, which will impact access to justice. Now, much is expected of the NPA in its fight against crime, including widespread fraud and corruption arising from state capture. However, without sufficient resources, these expectations will not be realized. It is equally important for the Hawks to have resources for forensic investigations required for many of the complex cases of fraud and corruption. And it also does not make sense to reduce the budgets of those entities that are able to recover ill-gotten gains for the state, such as the NPA, the Asset Forfeiture Unit, and the SIU. Now, as an example, the SIU reports that more than 50 civil matters were enrolled at the Special Tribunal to the value of 6.9 billion rand. The SIU has a mixed funding model that derives income from the National Treasury and from work done for state departments. the ACDP is concerned that State Department debtors will not pay the fees due to the SIU due to their own budget cuts. And this will have a devastating impact on the SIU, which already sits with a debt owed in the amount of 630.8 million. That is the debt owed by departments to the SIU. And it can then be very easy to stymie the SIU's work by not funding it adequately. This makes no sense, and this funding model must be revisited. It is also time to start recovering all those stolen state funds sitting in foreign bank accounts. The FIC, Hawks, NPA, Asset Forfeiture Units, SARS have extremely wide powers to freeze bank accounts and attach assets worldwide. It is lawful and possible to effect the civil recovery using the SWIFT banking system and the civil courts that of the jurisdictions to which the funds have been transferred using that very system. Artificial intelligence applications can also be used. One can apply ex parte, i.e. without notice, for an order freezing the proceeds of crime in an account wherever it is situated across the world. And we from the ACDP would urge our law enforcement agencies, state-owned enterprises and other state entities to approach those foreign courts for those freezing orders, which are obtainable within days of locating via forensic accounting where the funds are, no matter where they are, so that they can be recovered and brought back to South Africa. This will assist us in fighting crime and will assist us with the financial constraints that we are faced with at the moment. I thank you.
Thank you very much, Honorable Swartz. The next speaker will be Honorable Mola, ANC.
Thank you very much, Honorable Chair, the members of the House, members of the Executive, good afternoon. On this occasion of the debate on the budget vote of justice and constitutional development, and in keeping with the commemoration of the 25th anniversary of the Constitution, I begin with the words of the chairperson of the Constitutional Assembly, who was involved in the drafting of our democratic constitution, President Cyril Ramaphosa, when he said, and I quote, "The Constitution with its Bill of Rights is a mirror of our South African society. It reflects both the history from which we have emerged and the values we now cherish: human dignity, equality, and freedom. It proclaims to the world that we are a society committed to democracy, to the rule of law, and the protection of human rights. It proclaims to all South Africans, the landless, the homeless, the women, the workers, and the children of this country, that their basic needs and aspirations matter enough to be included in the country's constitution. The constitution was adopted to, amongst others, heal the divisions of the past of a deeply divided society which was characterized by strife, conflict, untold suffering, and injustice, and establish a society based on democratic values, social justice, and fundamental human rights. The Constitution was adopted to lay the foundations for a democratic and open society based on the will of the people." Honorable Chair, the roots of our Constitution and the Bill of Rights can be traced back to the founding documents of the African National Congress. Convened in Bloemfontein in 1923, the ANC adopted the African Bill of Rights. Themes which were central in the African Bill of Rights were the demand for land, freedom, the equality of all citizens before the law, and justice. 2 decades later, in 1943, the African Claims document was adopted. The ANC has been both a liberation and a human rights movement. The resolutions of the African Claims document find expression in the founding provisions of our much celebrated and internationally acclaimed final constitution. The ANC is ready to govern, articulated that the Bill of Rights would be enforced by the courts, headed by a separate newly created constitutional court, which would have the task of upholding the fundamental rights and freedoms of all citizens against the state, body, or person seeking to deny those rights. Our constitution guarantees 3 generations of rights. While most democratic countries guarantee first-generation rights, our constitution has entrenched second-generation rights, which are the socio-economic rights or second-generation rights. Since its establishment, the Constitutional Court has shown willingness to adjudicate on and enforce socio-economic rights in addition to political and other rights, showing the transformative purpose of our constitution. In the matter between the Road Accident Fund and another versus Ndedi, the Constitutional Court described our constitution as a transformative to the extent that it should ensure to the weakest sections of society the realization of their rights so they can enjoy a dignified life. In Batosta Fishing Pty Ltd versus the Minister of Environmental Affairs and Tourism and others, the Constitutional Court observed that the South African Constitution differed from other constitutions to the extent that all other constitutions assume all people to be equal. In contrast, the Southern Constitution recognizes the history of discrimination and as such strive to achieve equality. In President of the Republic of South Africa versus Hugo, the court recognized that the purpose of their new constitutional and democratic order was to establish a society where all human beings are accorded dignity and respect, irrespective of their membership to particular groups. Through the adjudication process, rich jurisprudence has been developed by our courts as aforementioned. Our courts have passed numerous landmark judgments which seek to protect human rights, including rights to access housing, healthcare, and education. The Constitutional Court in the cases of Grootboom, Subramani, and Treatment Action Campaign are just a few classic examples. Honorable Chair, the ANC government remains committed in the fight against crime and corruption. We welcome the efforts made by the Department of Justice and entire JCPS cluster in the fight against fraud and corruption. The department indicated that in enhancing the fight against corruption, it has an indicator dealing with the establishment of specialized commercial crimes courts. The department targets to establish 2 specialized commercial crime courts during the year 2021-2022. The department also reported that it will develop a position paper on the review of existing anti-corruption legislation and institutional arrangements. We welcome the commitment to strengthen the prosecutorial capacity of the National Prosecuting Authority by way of aspirant prosecutor program. The program allows young graduates to be recruited into the rank of the NPA. In line with our constitutional value of accountability, it was reported that an office of complaints and ethics will be established in the NPA during this financial year. The minister committed that the department will ensure that the State Capture Commission is assisted to complete its work. The commission will receive an amount of 75 million from National Treasury. This will allow the commission to complete its work and report. The Special Investigating Unit's principal function is to investigate serial malpractices, maladministration, and corruption in connection with the administration of state institutions, state assets, and public money, as well as any conduct that may seriously harm the interest of the public. The SIU also institutes and conducts civil proceedings in any court of law or special tribunal in its own name or on behalf of the state institution, and brings potential disciplinary matters to the attention of the state institution. While the SIU does not have the power to arrest or prosecute offenders for criminal conduct, it reports matters to the Directorate for Priority Crime Investigation, the Hawks, the South African Police Services, and the National Prosecuting Authority. The SIU works closely with the Asset Forfeiture Unit in the NPA, where its powers are more appropriate or effective in recovering the proceeds of crime. The SIU is part of the anti-corruption task team, which was established to fast-track investigations and prosecutions of serious corruption cases. And more recently, the Fusion Center, which was established in 2020 to provide a coordinated response by law enforcement and corruption fighting agencies to incidences of alleged corruption, fraud, abuse, or maladministration related to COVID-19 procurement irregularities. This demonstrates the importance, effectiveness, and efficiency of a collaborative effort by state institutions. It was reported that although the SIU's budget is reduced by 41 million in the financial year 2021-2022, it is in a strong financial position as it had managed to build up some cash resources over the last few years. However, this could change as it is planning to grow its headcount over the next few years to meet the high demand of incoming work. Notwithstanding the challenges faced by the department, we thank all the hardworking officials of the department and the South Africans who work tirelessly for the betterment of society. We wish all Africans a happy Africa Day. The ANC supports the budget vote. Thank you, Chair.
Thank you very much, Honorable Member. We'll now move on to Honorable Horn, the DA.
Thank you, Chair. Towards the end of last year, as others had pointed out, it was clear that the Department of Justice was on the brink of collapse. This, Chair, was despite the fact that it kept on spending close to 100% of its budget every year. When assessing this year's budget in APP, it's therefore very important to ask whether it assists the type of change that will make real improvements a reality. On this score, we are still very worried, Minister, about the state of affairs at the state legal services. We are not convinced that the interventions there are anything more than an academic exercise at this stage. We also take note of the plans to turn around the Master of the High Court. We hope these plans will work, but here is the difficulty. Neither the slow response of the Minister in respect of milestones, the Master, in respect of the milestones other than the issuing of letters of appointment, nor the perennial unavailability of personnel when widows and orphans are in need of assistance, some of the real issues plaguing this office are addressed by the targets the department has set itself. Therefore, we can only hope that the appointment of heads of office at the different offices will translate into improved services where it really matters. Chair, speaking of high-level interventions, we are thankful that a new Director General has finally been appointed for the Department of Justice. The fact that the person appointed was up to now your special advisor, Minister, of course makes a bit of a mockery of your argument the other day that your hands are tied when it comes to the continued appointment of the National Commissioner of Correctional Services. We see you, Minister, and we don't like your obfuscation on the matter of Mr. Fraser being kept in office in the face of what objectively speaking is information that should preclude him from ever again being allowed near any public funds. We know you have real influence on who your senior officials are. Just like you clearly had your way with the appointment of Advocate Mashabane as the new DG of Justice, you can do the right thing in respect of Mr. Fraser if you really want to. Nonetheless, Chair, we wish Mr. Mashabane well in this role as DG of Justice and have noted with interest that he has already spent some time listening to officials. Hopefully he has learned that one of the ways in which both staff wellness and the delivery of quality frontline services should be enabled is through the proper support of the functions of this department by management. Simple things like proper management of contract services so that magistrates' offices are not forced to operate without access to outgoing telephone lines for months on end, or the judiciary without access to online case law. And timely reaction to simple requests for basic maintenance of court buildings will go a long way. This is, of course, in addition, Mr. Mashabane, to improving financial management and access to justice for specifically the vulnerable, long-suffering parents who are dependent on our courts to get their papgeld from sometimes unwilling co-parents who spend long hours in queues, victims of domestic violence, victims of sexual crimes, victims of other violent crimes and commercial crimes, all while doing what should be done to strengthen the resolve of all involved in the fight against corruption. Indeed, a tall order, but a mission you chose to accept, Mr. Mashabane. Please make us proud. Chair, this budget vote, of course, also includes the Public Protector and the Human Rights Commission. Both of these institutions have suffered serious reputational damage over the last years because of the way in which it has discharged its duties. In the case of the Public Protector, anything more complex than ordinary bread and butter matters, like pension disputes, which pits individual South Africans against government in some way or form, has turned out to be a mountain too high and a valley too low for the incumbent. As a country which is still at a critical juncture in our fight against state capture and endemic corruption, we deserve much better from this institution, once described by our Constitutional Court as one of the most invaluable constitutional gifts to our nation in the fight against corruption. Chair, the Human Rights Commission is doing no better. Until the Human Rights Commission acts, for example, as forcefully against the failure of local governments in the Free State to give all residents uninterrupted basic access to clean water, an issue it has been asked to deal with and in respect of which it has done nothing more than to issue advisory reports, all while hundreds of thousands of poor and mostly rural Free Staters still have no proper access to water. Until it shows the same urgency and force in matters like these, than when it deals with the alleged shortcomings of the City of Cape Town and the Western Cape government, it will be viewed, and rightfully so, as nothing more than a special branch of the ANC. This brings me in closing, Chair, to another important institution which receives budget via the budget vote, the information regulator. The regulator is due to become very busy on 1 July this year, when its duty to oversee and enforce the protection of our personal information comes into effect. We are very worried that it's not yet positioned to deal with this task properly. The fact that it, on its own account, is struggling to recruit the right type and number of experts poses a grave danger to its functionality. If one considers this against the stated intent of the regulator to use all powers available to it from the 1st of July, it needs no special insight to know that there is grave danger that this body too is at a risk of also operating in a selective, inconsistent manner, and that it may also soon find that it's viewed with some skepticism by South Africans. It should guard against this. Thank you, Chair.
Thank you very much, Honorable Horn. I now call on Honorable Janji from the ANC. Honorable Janji.
Thank you, Honorable Chair. Just as I started to indicate that I have received a favorable 2 minutes from Honorable Magwanisha to add to what I want to say. Honorable Chair, it was the German philosopher Friedrich Engels who argued that the evolution of society was characterized by a decline from matriarchal societies where ownership was communal and production processes were egalitarian in nature. As new societies evolved, they were characterized by the emergence of classes and private property, and later the location of power in the state. Once these societies were established, sexism, racism, class inequalities, and other forms of discrimination and subjugation began to emerge. The ANC recognizes the country's historic oppression of Africans in particular and Blacks in general. This understanding also recognizes that the South African society, like many other societies, is patriarchal and anchored on the historic marginalization of women and the perception that women are inferior to men. While all Africans were subjected to conquest, colonial rule, and dispossession, the way in which women and men experienced these differed, as did their political, economic, and legal statuses. These differences shaped their particular responses, helped to determine the issues they took up, and the methods of struggle adopted. The main objective of the National Democratic Revolution is to attain a non-racial, non-sexist, united, and prosperous society. Throughout history, women have been marginalized, regarded as the weaker sex, and incapable of fulfilling the duties which were traditionally considered as being for men. History teaches us that women in most parts of the world, including South Africa, were considered perpetual minors without rights to property, to inherit, to vote, to hold legal power, to hold certain occupations. Married women were legally dead in the eyes of the law. History teaches us that women were relegated to the lower rungs of society. Throughout all of this, history also teaches us that the bodies of women have been considered and treated as objects. And sadly, you have that still continuing. The ANC's theoretical approach to gender transformation and equality is informed by the women's experience of triple oppression on the basis of their race, sex, and class position. We continue to anchor our resolve on a pursuit for a democratic society, which is a society that is to address the challenges within the class, race, and gender contradictions, and as such, we will continue to champion for gender equality and the empowerment of marginalized groups in society. The President, in announcing the emergency response plan, made and listed some of the following measures. One, around prevention, the issue of gender sensitivity, the training of law enforcement officials, prosecutors, magistrates, and policymakers, so that those who are found in breach of these responsibilities in this regard will be held to account. We have brought to Parliament suspension of magistrates who have failed in this regard. The strengthening of the criminal justice system, a proposing of a range of legal and regulatory reforms that came to Parliament, engagement with the judiciary on the role that it can play in supporting the national effort to end GBV, to ensure abusers, rapists, and murderers know that they will be caught and be punished, that the state should oppose bail for rapists and those that are suspected with that, to strengthen programs that must rehabilitate offenders and youth at risk. And we've spoken a lot about this under the Correctional Services debate last week. And that all parliamentary committees to prioritize these areas of legislative reform and ensure that we have effective legislation in place without delay. And we're busy with this. We must commend the Justice, Crime Prevention and Security Cluster on its work to ensure perpetrators are brought to book and that the survivors receive the necessary help. As the legislative arm of government, we must commit to ensuring gaps in existing legislations are tightened to assist in the JCPS cluster with its work. To this end, we must indicate that the Criminal Law, Sexual Offences and Related Matters Amendment Bill, the Domestic Violence Amendment Bill, and the Criminal Matters Amendment Bill, what we call the 3 GBV bills, are at an advanced stage in the Justice and Correctional Services Portfolio Committee on a weekly basis, including this week, and hopefully concluding next week. We're dealing with these matters. We must also hasten to make the point that the issue of the bills and legislation is only an enabler and not the solution on its own, and that we need to deal with more fundamental issues of the emancipation of women and attend to the mindset of society and as mentioned earlier, the issue of patriarchy. The Department of Justice has progressively rolled out sexual offences courts. Because of the intrusive nature of sexual violation, many survivors of sexual abuse choose not to report this crime, mainly because of shame or fear of not being believed. The sexual offences courts are therefore established to give them an experience defined by solace, care, compassion, and justice. And we want to ensure that, Minister, this issue is going to be prioritized. We're happy with your 100 and more kind of courts, and we'll be, as you know, we're watching the Kailicha court in the Western Cape. But the major issue that we must also attend is the issue of the family breakdown. It is a major issue that does not need any shortcut, that many of the problems become symptoms. And as long as that is not attended, we are going to continue to have challenges. Let me, Chair, at this point, attend to some of the issues that have been raised by the opposition. Ndizawuqala phaa kwi-DA. Honorable Breitenbach makes the point about the APP being a false sense and making more promises. I want to indicate to Honorable Breitenbach that I think what you have said, you have left something that I thought you would say, that in going forward and already the ANC is leading in that journey of ensuring that we play an effective oversight, ensuring that the APPs are in line and the annual report are going to reflect that. We're already doing that in the portfolio committee. I was hoping that you would make that. So we're in the same journey on that issue, but the ANC will be leading you on that. You've raised the issue about the NPA. The only message I want to share with you and leave you with, and this is what we all attended to when the NPA came in front of us, that the NPA has presented to us and has demonstrated that there is a rescue plan under the leadership of Batoyi. And that rescue plan is promising and is emerging. We already, besides what is on paper, were able to see not only the light at the end of the tunnel on a daily basis with evidence we see the role of the NPA. Society can attest to that. And so it is an issue that we'll continue monitoring, and we're determined, again, as the ANC, to lead on that oversight, as we have always been doing. The issue of the recruitment and retention strategy is a task that we gave the NPA 3 weeks ago or a month ago when they come to us, for them to focus on that so that we've got a sustainable solution going forward. Interestingly, you have raised a possibility that the Democratic Alliance for a Change is now going to advocate for a constitutional amendment. I'm saying for a change because you've always been resistant to any constitutional amendment. And this constitutional amendment, more curious for me, is that it seems that you have learned from the African National Congress about how it does things, because you're wanting to do the amendment in order for the country to establish an integrity committee. I can share with you that in the ANC, our integrity committee is working. You can see results. And maybe a little advice on you would be, before you go to amend the constitution, start in the DA, follow the ANC, create an integrity committee, and deal with some of these claims of qualifications of your members, because integrity committee works. The fact that you think that it could be something for the country, it demonstrates that. Let me go to the EFF. Listening to the EFF, as always, it's quite clear, Chair, that it's not worth giving attention to the EFF populist and the gallery stance. Casting aspersions on the courts and the judiciary is an attack on the independence of the judiciary. It's an attack on the supreme law of the land. And quite clearly, the EFF plays on the racist card and yet accuses other people of being racist. Hence, I want to make the point that it is really not worth responding to many of the issues that the EFF has put forward here. The Freedom Front Plus, Akhbar Mulder. I'm looking forward to what you mean by an improved mode of constitutionalism. I'm really looking forward to that, and I can just give you the part course that on Friday we're debating the anniversary of the 25th anniversary of our constitution. Kanivachi, ek lek my lippe, senior Vrydag, and I debate. Thank you very much, Chair.
Thank you very much, Honorable Janki. Honorable members, we will now move to the last speaker of the debate, the Minister of Justice and Correctional Services. The Honorable the Minister.
Thank you, Chairperson. With regards to the members' views that they've raised, we want to thank them for their inputs, and also for strengthening our resolve for a constitutional democracy. And with regards to the Master's Office, the department is developing an online deceased estate system. This will be a convenient method that allows people who want to report deceased estates to do so in the comfort of their homes, offices, or in any remote location. This will help us to cut a lot or reduce the queues that you see across the country in the Master's offices, and hopefully will go a long way towards service delivery. And I want to agree with Honorable Danji that these plans that were presented are just not nice on paper. They are plans that must be acted on, and there must be action, and there will be work that is going to be done. It is for this portfolio committee to then hold us to account for our words and for what we have brought to the House. And I want to confirm, Honorable House Chairperson, that the NPA is bringing in new blood to the National Prosecuting Authority. In the last financial year, they've appointed 415 aspirant prosecutors. It's a program that we've revived, and we are continuing to give support to that program. They will continue to recruit new and sharp minds who have just graduated from our universities, and the NPA will be again an employer of choice. With regards to the TRC cases, Chairperson, it is unfortunate that the EFF choose to forget that out of their own wishful amnesia, that I'm new in this department. These cases of the TRC have been here since 1994, or even before. But the NPA is now putting together a team that is going to be led by a senior NPA person who is going to help in terms of both the investigations that will be done by the Hawks and the process of charging. And this will be a team that will have a multidisciplinary skill, and they've got cases that already are in the pipeline that they're dealing with. If members remember the current ongoing inquest of Ahmed that ended of Ahmed Timoli is an outcome of that process. And there are many such processes that are unfolding, and the NPA is responsive to this, including the Hawks that has also assigned a group of investigators to assist with this process. So the new broom is helping this process. I was not there in 1994 or before that, and but I understand sometimes it may not be wishful amnesia. It may also be because the EFF is also new, so they could not have time to go to the historic records to see that the minister is new in this. I was not there when these cases of the TRC started, but we have given all our support to the NPA to help and start this process to ensure that all the TRC cases are attended to and the families find a finality on these matters. And I cannot agree more with the speakers that says that it's important for us to continue to protect and support the work of the judiciary, because it is the most important cornerstone in our democracy. And any unnecessary, spurious allegations, they do not take us anywhere, nor do they take this democracy further. But it's shocking that some of the organizations that continue to doubt and attack the judiciary on a day-to-day basis, like the EFF, they are in our courts trying to find justice. Why will you go to a platform that you believe is hijacked, it's bought, it lacks integrity? It is because they trust that system, that this system works. That's why they continue to use these courts, because they know that the judiciary is independent, is able to dispense justice without any fear, favor, or prejudice. So this is what all of us as a society must cherish, we must protect, and we must ensure that it is what must continue to give credence to the life of the Constitution. And I can't agree more with the Honorable Janji with regards to the supremacy of the Constitution. Mr. Mulder maybe might be yearning for the apartheid past. That's why he believes this Constitution is not supreme enough. It's not giving what he used to benefit in the past. But this Constitution has shown to work. It's a good social contract for the people of this country. We just need to enhance it, strengthen it, so that all South Africans should benefit from the fruits of the Constitution. Thank you very much, Chairperson, and also confirm that I heard the advices of Mr. Swart with regards to the use of the foreign jurisdictions with regards to freezing orders, and I hope Mr. Anton Duplessis has also heard him. Thank you.
Thank you very much, Honorable Minister. That concludes the debate and the business of this virtual mini plenary session. The mini plenary will now rise.
Recording stopped.